Good afternoon, Your Honour. My name is Monica Hodson. Today I'm here on behalf of the defendant Otto Lowtower. Your Honour, my client has been charged with possession of more than 200 grams of MDMA pursuant to Section 9, Sub 1 of the Drugs Misuse Act. If it pleases Your Honour, I'll dispense with full citations. The defence submits its application under Section 590 A 2E of the Criminal Code to seek that the court exercises its discretion in excluding all evidence located as a result of the vehicle stopped by Senior Constable Targaryen on the 1st of June 2024. Your Honour, this application intends to show that all evidence against Mr. Lowtower from the stop and search, including the MDMA tablets, the denim vest, and any oral statement, were acquired by the misuse and contravention of multiple statutory requirements. I therefore humbly submit that the use of this evidence may be in breach of public policy. In dealing with the police stop, the officer misused the power vested to him under Section 60 of the Police Powers and Responsibilities Act, or the PPRA. Section 60 Sub 1 permits an officer to stop a vehicle for a prescribed purpose, listed in subsection 3. Senior Constable Targaryen alleges he stopped my client's hired vehicle to exercise his powers under Section 60 Sub 3B to carry out a licence check, which may amount to the purported purpose of checking compliance with the Transport Act. However, my client was never charged with any traffic offences. Additionally, Senior Constable Targaryen is attached to Task Force Minima, which involves investigation of drug and gang-related offences. Targaryen's onboard computer system had a direction appended to the hire car's registration with a possible association to the Green Traders gang. However, this detail has nothing to do with checking my client's licensing. Your Honour, I therefore submit that the interception of my client's hire car was unlawful because the purported purpose of stopping the car was not to enforce the Traffic Act, but instead to misuse Section 60 in determining if there were any drugs in the vehicle. In stopping my client's hire car, Senior Constable Targaryen displayed a blatant disregard for the law. In R. Davis, Justice Davis held that the interception and search of a vehicle is unlawful where the power under Section 60 to investigate traffic offences was being systematically misused to stop and search cars for drugs. All evidence was therefore excluded, as it is in public interest to denounce the conduct of police officers who misuse their statutory vested powers. It was held that public interest outweighs the interest for the prosecution of drug offences. Under Section 31, Sub 1A, Senior Constable Targaryen can also stop my client's vehicle if he reasonably suspects a prescribed circumstance, which may be unlawful dangerous drugs under Section 32, Sub 1C. The Q-Light system reporting my client's alleged suspicious activity is too broad to undoubtedly associate with the possession of MDMA tablets, because suspicious activity could relate to anything. Therefore, I submit the stop and search for the drugs is unsupported by Section 32, Sub 1C. Your Honour, I submit that Senior Constable Targaryen unlawfully intercepted my client's hire vehicle to circumvent the reasonable suspicion required by Section 31 to stop and search a car without a warrant. This is supported by Justice Davis's decision in R. Hines Rabbit, which held that a misuse of the PPRA may result in an unlawful search and the exclusion of that evidence at trial. Another prescribed purpose is Section 32 Sub B, which may allow Senior Constable Targaryen to stop Mr. Lowtower's car because he was consorting with Mr. Cold, a known offender and a member of the Green Traders gang. However, Your Honour, we submit that Section 32B merely permits Senior Constable Targaryen to stop the vehicle, not to search it without a warrant. This is because neither my client, his passenger, or his vehicle was detained under Section 31 Sub 1C, which would have been necessary for the officer to search the vehicle without a warrant. I submit that Senior Constable Targaryen did not possess any power to search my client's vehicle. I further submit that he failed to apply for a post-search warrant approval under Section 161. This demonstrates a deliberate and reckless disregard for the law. We submit the Crown's evidence was unlawfully obtained as a direct result. Bunning and Cross illustrated evidence obtained through unlawful police conduct should be excluded in order to uphold public confidence in our legal system. Senior Constable Targaryen's actions was not in response to any pressing circumstance, and my client was not charged with a highly serious offence. The purpose of the PPRA in Section 5 is to protect individuals, like Mr. Lowtower, from unjust treatment by officers. The Crown's evidence against my client was obtained through a willful breach of the PPRA. As a result, the defence respectfully request Your Honour to exercise the Bunning and Croft discretion to find the evidence inadmissible on the basis that admission may be contrary to public policy. In relation to the denim vest, there's no evidence to suggest that it belonged to my client. Your Honour, my client denies and continues to deny that he is a member of the Green Traders. Moreover, the vest does not rationally relate to the possession of MDMA tablets. In following the precedent of Goldsmith and Sandilands, the vest only is relevant if it can prove the probability that the MDMA tablets belong to my client, which it cannot. Your Honour, I'd now like to address my client's oral statement. After Senior Constable Targaryen pulled Mr. Lowtower over, my client stated, quote, "I've got nothing to do with it, it's not mine," end quote. This statement does not suggest my client was referring to the MDMA tablets which were mixed in with the hard candy. Instead, I submit that in this quote, my client could have been denying ownership of the denim vest or the hire car that he was driving. Your Honour, the Crown's evidence against my client was obtained via misuse of the PPRA. Following the precedent of Ireland, convicting my client of Section 9, Sub 1 of the Drugs Misuse Act would be too high a price to pay when considering the unlawful acquisition of that evidence. Respectfully, Your Honour, I ask that you exercise the Bunning and Croft public policy discretion to exclude all evidence from the trial which relates to the unlawful vehicle search. Thank you, Your Honour. Unless I can further assist the court at this time, that concludes my submissions.